Well, good morning. My name is Paulo Sotero, Director of the Brazil Institute here at the Wilson Center. On behalf of my colleagues at the Wilson Center, our team at the Brazil Institute, I'd like to welcome you this morning for one more lecture in our series, Rule of Law in Brazil, that we started a year ago. Minister Torquato Jardim, who honors us with his presence here this morning, is the 9th speaker of the series. As I mentioned to you the other day, Justice Luis Roberto Barroso will be with us on September 8th, and we hope to have a few more speakers and by the time we close the series and publish the proceedings of the series, all lectures with comments from our partner in this venture, Judge Peter Massetti, federal judge, District of Maryland. Also comments, introduction by our dear chairman of the Brazil Institute, Ambassador Tony Harrington. I would like to give the floor to Ambassador Harrington, who will do us the favor of properly introducing our distinguished guest, Minister of Justice and Public Security in Brazil, Torquato Jardim. Thank you very much, Tony.
Thank you, Paulo, and good morning, everyone. It's an honor to welcome Minister Torquato Jardim to the Wilson Center and to Washington. We're always glad to have Senior Federal Judge Peter Massetti, who's partnered with the Brazil Institute on this series on the rule of law in Brazil, as Paulo described, co-sponsored with the Washington College of Law at American University. Those of us who follow Brazil know that the present moment is a difficult one for the country, but we know that Brazil has faced and overcome difficult times in the past. We've had in this country difficult times and overcome them, and that's the way life is and the body politic. When I was ambassador to Brazil, I saw firsthand the resiliency of the Brazilian people, their ability to endure and overcome challenges. In recent years, we've also seen the resiliency of institutions, public institutions in Brazil, in which the minister plays a central role. As I have observed before, those of us who are friends of Brazil are also optimistic and hopeful that the country will come out ahead from the current challenges and perhaps point the way for other countries who face similar challenges. As the current Minister of Justice and Public Security and a former professor of constitutional law at the University of Brasília, Minister Jardim is well qualified and uniquely positioned to speak on the current challenges facing Brazil and the need in any democratic system for institutional checks and balances, and in this case, the somewhat unique system of checks and balances that Brazil has. The minister holds advanced degrees from both Georgetown and Michigan law schools. There are probably some other Georgetown folks or grads or students here, and has extensive experience in both public roles and as a private lawyer. Prior to his appointment as minister, he was a judge on the Superior Electoral Court, Minister of Transparency, and Comptroller General of the Union. And he represented Brazil at the United Nations Committee on Transnational Corporations. Minister, we look forward to hearing your perspective on these complex issues facing Brazil today and the institutions that are addressing them. After your remarks, Judge Massetti will offer a few thoughts, and then we'll open the floor for comments and questions. The floor is yours.
Thank you, Ambassador. Good morning, everyone. Ambassador Harrington, Mr. Sotero, Judge Massetti. It's a pleasure to see you again. We've been meeting over and over, different symposiums over the past, 30 years maybe? It's been a long time. It's a pleasure to be with you. What I will try to do is a bird's eye view of some of the constitutional issues Brazil's facing from a very practical point of view. I used to teach constitutional law, but I have not been doing it for 20 years. Legal practice took me over. So I'll try to be practical, and the cases, the actual cases I'll refer to are the ones having to do with the Ministry of Justice in particular. But let me start by pointing out what I would refer as maybe traits or roots of Brazilian law. Some of the criticals and analysts say that our law is Iberian, derecho ibérico in Spanish. Why is that? As typical of former colonies of Portugal and Spain in the Americas, our legal institutes and institutions are derived from a mix of Italian law, French law, German law, English law, American law, and we end up with a fruit salad of legal concepts. I will go into the detail. For example, how can you expound US-inspired judicial review resorting to French law? That is done all the time. If you read the major texts on Brazilian constitutional law by the best known professors, they will be referring themselves to other sources of law instead of the Anglo-American tradition. The French passed the constitutional amendment in 2008, transforming part of the jurisdiction of its Constitutional Council to give it a capacity of judicial review. So if it took America 200 years to find out what truly is the role of the judiciary under judicial review, can you imagine the French in just less than 10 years? Same with Civil Procedure Code. And it is most evident when we speak of procedural law in Brazil. If one's been to Italy, he sources Italian. If one's been to Germany, he sources German. And then have this confusion, Italy versus Germany. Nowadays, at our Constitutional Court, our Supreme Court, we have a major conceptual, cultural battle between Germany and Yale. That's the two most prominent intellectuals in our Constitutional Court. One has attended Yale, the other has attended a German university whose name I cannot manage to pronounce.
I know it.
So he's your friend, he's my friend. We know him very well. So very often, the understanding of a major body of law will be dependent on which country the interpreter has attended. I remember a major case in the Superior Electoral Court when I was a judge there. The prosecutor general was from Yale, and the counsel for the defense had attended Harvard. I was the court rapporteur, being a Michigan alumni, and the case was decided by the Federal University of Minas Gerais. Minas won again because it was a tied case, and the president of the court was from the Federal University of Minas Gerais. In Brazil, Minas Gerais never loses. The case of our Constitutional Court, it's either a Constitutional Court or the highest appellate court. There's this double function. They have not been able to decide even under the 88 Constitution, which seems to have intended to expand the role of and create a truly constitutional court. But for years, you could challenge any decision of the National Court of Appeals. For those of you who may not know the Brazilian judicial system, we have in the federal system the district courts, the appellate courts, circuit courts, and the National Court of Appeals, which you don't have in the U.S. But the Constitutional Court would control major decisions of the National Court of Appeals through writ of mandamus or habeas corpus, as you know, are very summary procedures. They had to quit that interpretation of the Constitution because they had a huge workload. So that was a major argument. Let's change interpretation because it's given us much more work than we can respond to. Another example, we try in our Constitutional Court follow English language law, as I say more generally, the idea of case law and precedents. It doesn't work. It does work to the point that we had to pass a constitutional amendment in 2004, making the letter of the law, making decisions of the Supreme Court binding on the lower courts, binding on the judges, by issuing mandatory summas. I would translate with the Latin word dictum, orders. The case would be interpreted in a very short sentence, like 4 or 5, half a dozen lines, to be mandatory erga omnes. I can't avoid the Latin, binding on the society. But there are judges, district court judges, who refuse to decide in accordance with the dictum, with the dicta or the dictum. A friend of mine who sits on the criminal section of the National Court of Appeals took a decision, sent it down to district court. A few days later, he received a message, a Twitter message. That's new in the judiciary as well. Judges start deciding with Twitters as well. So, in that quote, the judge, "Your Honor, I apologize, but I do not feel comfortable enforcing your order," unquote. And he refused to do so. So it's another trace one has to keep in mind when trying to understand Brazilian law. There are so many intellectual sources, historic sources, that we have not yet, after so many years, worked out a way to make the jurisprudence and make case law coherent, consistent, and followed by district courts. In business, for business lawyers, this is particularly difficult. For investors, this is particularly difficult because you can't exactly plan 5 or 10 years ahead, because depending on the change of the composition of the court, a full body of precedents can just be overcome. So my suggestion is our system shows a not coherent set of mechanisms or sources for interpretation or construction of the law. The major consequence is that Congress occupies a space of legislation which could have been worked out or decided or made stable by the judiciary. So legislation over and over imposes itself on the courts. And were this to be a 60-hour course, I would go over half a dozen or maybe a dozen examples of major changes in the Constitution itself and in the statutory law just overcome this case law, precedents of the courts. Another second, it will be just to differentiate, to sum up these traces of Brazilian law, is concentration of power. The tendency of our Constitution, the tendency of statutory law in Brazil and the legal culture in general is, well, to say authoritarian would be too much, erase that. Concentration of power. In the executive branches, the president, the governors, and the mayors. A preeminence, I will give you just one example. of the executive preeminence. Under the Constitution, bids are mandatory for businesses with the government. Whatever government buys or hires, whoever hires has to go through a bidding process. But the constitutional clause which makes biddings obligatory, mandatory, begin with this opening statement. Unless otherwise indicated in the statutory law, comma, biddings are mandatory. Then we go to the statute. There are 32 escape routes to avoid biddings. One chief executive would have to be very incompetent not to choose the lawyer who can find one of the 32 escape routes to run the budget. Well, that has led to corruption at large, and Lava Jato car wash is just the most blatant example, consequence of this incoherence in the Constitution itself. Another trace of concentration of power is the preeminence of national government. Take public security, for example, which is one of my 17 different roles in my ministry. One of them is public security. The federal union, it has the exclusive competence to pass criminal law, the criminal statute, and the criminal procedure. But then the federal union and the states concurrently pass legislation on penitentiary system, on how to manage the penitentiaries. But because of our tradition of preeminence of national government, the surprise that have caused some governors and mayors, I've been asking them, please read the Constitution. It's your job, it's not my job. But the expectation, the cultural expectation is to have the national government. And I'm saying national government, not federal government, because it's a very, I wouldn't say technical, but academic distinction between federal government, state government, and municipal government. And national is the jurisdiction which is given to the federal government to act on behalf of all. That's what I'm saying, national government, because it is encompassing initiatives which should have been given, it's been given by the Constitution to the states, should be implemented by the states. I'll give you just one example again in my field of work nowadays. You may have read the terrible tragedy of the Presidium of Alcaçuz in the northeast of Brazil. People were beheaded, etc., etc. But it is a state prison, and it's been under actual federal intervention with federal agents, because the state government doesn't run it. But there's a time limit, there's a budget constraint for the federal government to substitute for the state government full time. It's been 6 months. They want us for another 6 months. We have 90 people because we need volunteers to be there. We cannot draft people and stand there. And we don't have the budget for that. But again, it's a tradition to expect the national government to fill the shoes, which Constitution itself clearly gives the role to the states and the municipalities. And a final example of this national preeminence of national government, the concentration of power, when it comes to budget, 2/3 of revenue collected by the national government is not shared with state governments. Again, there's a constitutional partition of revenue, as we name the share of states and municipalities in the national revenue. But 2/3 are in the hands of the national government. That is to say, those who drafted the Constitution in '88, they themselves kept the tradition. They did not, as they transferred to the states a number of issues to deal with, they did not transfer the source of the budget. Sum up this first part. Theory does not match practice. Different countries which inform different bodies of law. Practice is not settled law. Courts are seldom a stable source of law, to the point that, like the National Court of Appeals, it has 2 sections, to deal with taxation. They don't agree with each other every time. So have another appeal to make the two of them decide as a sole body. So keep on creating appeals so as to search for a more stable body of law. Executive preeminence and preeminence of the national government. Well, this cultural setting informs what we call independence in harmony, which is not exactly checks and balances. We call independence in harmony among the three powers. Before '88, before the present Constitution, we had a classic executive, legislative, and judiciary tripartite system. For instance, the Union's Accounting Tribunal, our version of General Accounting Office, which is a court under Congress, not a court within the judiciary, was a total dependency on the legislative. It was not an independent court. Court appointments were never refused or criticized. Judicial review was very limited. Budget was stamped by the legislative, was imposed on the judiciary. The prosecutor general was appointed by the president and removed at will until what I call the constitutional cataclysm of 1988. And why do I use this strong word? Because none of us who worked in the drafting of the Constitution, I had the honor to be very active, none of us ever anticipated the consequences of what the construction of the Constitution would bring about. None of us. None of us imagined some of the changes that we will mention here now that were brought about under the 88 Constitution. Was so much more innovative than we expected to be. We thought we were drafting limited clauses, but the younger generation of judges, prosecutors, and legislators, and civic leaders, they just constructed, distinguishing interpretation from construction. That's why I said construction of the Constitution. What came after '88? One major change from which all the others derive. Principles became legally binding and self-applicable. Take Article 37, for instance, the preconditions of administrative act, which apply to everything. Morality became a legally binding norm. And what is morality under the law? It became whatever the judges chose it to mean. So there was this major break with tradition. Until then, judges would not dispute the merits of the administrative act. They would check on the formality of the act. If the issuer was the one who could issue the decision, it was bound by the law, it was well argued, whatever. But the merits would never be decided or checked by the judges. Now, judges control the merits of the administration policies and decisions. I will mention some court cases. They are part of the administration. That was a major change. And from there derived the others I will refer to. But again, impessoalidade, that the statute had to be come in the abstract. It could not be bound exclusively to one individual or one group. It had to be universality of the law. So all these, but it began with the morality. It is whatever the judge chooses it to be. It's a major check on the Congress and a major check on the administration. One case, the Supreme Court, a judge, a panel of the court was decided an habeas corpus case, and as obter dictum, en passant, as the French say, the judge said that abortion should be legal until the 3rd month. And the country just, wait a minute, that is not at issue in this habeas corpus. How come it's being Why is it being argued? But it is large expansion, and we have not seen the end of it, I would not say intrusion, erase that, but the participation, active participation of judges in procedures which traditionally one would expect would be part of Congress or the administration. A second major transformation. Tribunal de Contas da União, TCU, the General Accounting Office Court, although still an advisory body to the legislature, was granted a new jurisdiction. It's been given unlimited control on the expenses by anyone of any sort of public revenue, not only a posteriori, after the money is spent, but as the money is being spent. So Tribunal de Contas da União has now permanent investigative teams, just like the Prosecutor General's office, just like the federal police. It has permanent investigative teams anywhere in the country where federal money from any source is being spent. Many people criticize former President Rousseff for not putting forward her famous PAC program, PAC program, to expand the economy. But very few people take notice that 50 of the major constructions initiated by her government were suspended by the TCU. Very few people take notice of that. These investigative teams will report to one of the court members, and the court members by himself or herself, there's a lady there, suspend the continuation of the program or the project. Well, I had to face that in my previous role as Minister of Transparency. I had to negotiate leniency contracts on a number of foreign countries and companies and Brazilian companies. And one day, there came TCU to talk to me. I thought they were being a social visit. I had just arrived there. No, we're here to investigate you. Hey, I have been here 48 hours. So what is there to investigate? Everything which happened before. And so I managed to have a working situation which was good for both. I would invite them in. I wouldn't wait for them to come. I would invite them in. I'm starting investigation A on such a date. Please send in your troops. They always sent their troops. So we were working together all the time, but it's part of their constitutional role. It's given them huge power, to the point that 2 days ago, they invited a number of cabinet members to their offices to present them a new program to be launched by this TCU, which will dispute, that's the word, dispute, the very choice of public policies. We will have to report, we as the executive, will have to report to them before taking the final decision on public policy, because have a new program on governance. So that's also a major issue. A third change, the Supreme Court issues injunction orders mandating Congress to enact the proper statutes which make constitutional rights enforceable. If not, the court will legislate in concreto. Any fundamental right that one has under the Constitution, if not implemented by statute, if not implemented by the executive, the court will implement it itself. For injunction orders, and that has created a huge problem for me, the Supreme Court issuing an injunction order to the executive prohibiting the impoundment of budget expenses crucial to the effectiveness of constitutional rights. You know, impoundment, it's not cutting the budget, it's waiting money to make the expense. We have a penitentiary fund. It's like 2.5 billion reais presently, or 3 billion reais presently, to be spent on the penitentiary system to improve conditions, living conditions and security conditions, all having to do with reforming or modernizing penitentiaries in Brazil. But we are short of money. We don't have, we normally have 10 minutes more. It's a whole basketball quarter. I'll make it short. I'll make it short. I used to play basketball, so 10 minutes ages.
If you can make it in less than 10 minutes. Go ahead.
So we were given the order not to impound the penitentiary fund. We have to spend the money. I just asked Treasury to send in the money. They don't have the money to send. We don't know how to work that out. Another major change is the Ministério Público Federal, the Federal Prosecutor's Office, whom you met 2 days ago, and I'm sure he expounded the jurisdiction of his entity. The clauses are very open in the Constitution. It is the role of the prosecutors, the Federal Prosecutor's Office, the defense of the legal order, the defense of the democratic regime. I'm quoting the Constitution. And one can imagine one can do almost anything. What is the new tripartite operation then? Well, executive vis-a-vis legislative. Bills have become bills. It's long ago, it's past the days in which the executive would send a bill to Congress and have it approved. Every single bill is thoroughly, strenuously negotiated with Congress. Active groups within Congress, there's no a major party, no major philosophy in Congress nowadays. It's micromanagement of micro-democracy, as the old thesis from the 70s. And in my case, I have the gun lobby, I have the Indian lobby, I would say the anti-Indian lobby, and the anti-drug lobbies. So whatever, whichever initiative one thinks of has to be carefully negotiated. Luckily, all this has been going on under the terms of the Constitution, and over the past 14 months, 14 major decisions proposed by the executive have been approved in Congress. Well, vis-a-vis the judiciary, as I say, should either the executive or the legislative fail to give meaning, enforce the Constitution, then the court will decide. For instance, since I have been running out of time, for example, one of the judges, Justice of the Supreme Court, Justice Barroso, who will be with you here next September, he's suggesting that if the government cannot guarantee, if the executive cannot guarantee living conditions, decent living conditions in the penitentiaries, in the prisons, then there should be a balancing out. Instead of having the federal government prosecuted in court for compensating for moral damages, then for each day spent in a prison under degrading conditions, 4 to 7 days should be subtracted from the sentence. So if one spends 1 year in degraded conditions, he would cut 7 of his sentence, which is very controversial, but it is under discussion. And there's one, well, I've mentioned the one having to do with prison terms. We either spend the money or I don't know what's going to happen to me because I don't have the money to spend and do. And just to finalize, the Supreme Court took a major decision on the Yanomami Indians in the north of Brazil, Raposa Serra do Sol, and imposed 19 conditions for implementing land in the protection or the demarcation of Indian lands. The court forgot one thing. Indians are not Indians as a whole. I've met with 100 of them, 14 different ethnic groups. Rondônia is not the Amazon. The Amazon is not Roraima, which is not Mato Grosso do Sul, which is not Santa Catarina, Rio Grande do Sul, Maranhão, Bahia do Norte, Bahia do Sul. The north of Bahia is one thing, south of Bahia is another thing. Each one is a different thing. When I take these 19 preconditions, if anyone finds an answer, has an answer, please tell me. I want to know. Plus, the formality of what they sold, say that the Indians have their ancestral lands recognized, those in which they were occupied on October the 5th, 1988, when the Constitution was passed. One has it's easy to understand that it's not feasible. Many Indian tribes, many Indian groups were not living in their ancestral lands on October the 5th, 1988, because they had been forced out under gunpoint in a number of situations. So it would be like corroborating the illegal situation of having them out of their lands. Well, closing up, suggestions for foreign investors, scholars, those who study Brazil. Remember, the Constitution prevails. We have been through 2 presidential impeachments, a number of crises of any sort, of all sorts, economic, political, social, and the military did not go to the streets. The dispute was without the active participation of the armed forces. The Constitution has created the proper channels for resolving it. What is to look for? The judiciary, the Supreme Court will continue to meddle into politics, into management. The judiciary will go on with Lava Jato, it will not be stopped. The Public Prosecutor's Office will continue to be investigative, proactive. It has to. It doesn't have the choice not to be under the Constitution. Congress will continue to be consensus building with the executive. I find that extremely relevant, although too many Brazilians think that the executive is weak or the Congress is overpowering itself. No. Consensus building is so rare in our political life that when you have a president who has spent more than 20 years in Congress and has presided over Congress 3 times, 6 years, it is part of the construction of the Constitution, the construction of democracy, to build consensus in Congress. We have 28 political parties in Congress, so it's definitely a long challenge, consensus building. The TCU, Tribunal de Contas da União, will continue to be active, more investigative. A major change in politics in Brazil now is social engagement, let's say Twitter and Facebook. I still don't use Facebook or Twitter, but there are 2 assistants of mine who do that all the time. They just get the news. See, for example, the mayor of São Paulo, how successful he has been in communicating with the people, with the press, with the country, showing what he's been doing, because he makes extensive use of this modernity. Trade unions will have a new role. Investors should keep that in mind. The reform of the labor law, which was passed last week, and less revenue for trade unions. The imposto sindical, the trade union tax, was extinguished. So it will be a major challenge for trade unions to find new sources of revenue. They will have a new role. I have to say that public safety, public security will continue to be a challenge for a good many years. We will not overcome the massive challenge we have with public security at the federal level, at the state level, at the municipal level, in the short run. We are beginning a program, a major program in Rio de Janeiro. It's slowly being built up. It will start at full speed. It will begin at full speed August the 1st, but challenges remain. And the choice I've made in the ministry is to improve on technology more than in personnel. Before we decide what is the profile of the police officer of the future, we have to decide what technology we can make use of in the future, but so that in a second step, decide on the profile of the police officer. And that is one of the major reasons for my trip to Washington. The executive will continue to function well in spite of the critics and the opposition, because it is consensus building all the time. Having said that, Sotero, it's still under 10 minutes. I think I've given you enough to chew. Thank you so much.
Thank you very much. I would like We invite now Judge Peter Massetti to offer his comments.
Thank you, Paulo. Minister Jardim, Ambassador Harrington, and dear friend Paulo Sotero. Minister, particularly, it's nice to see you again after a few years and the times that we've been together in the past. I thought it might be interesting for me this morning to try and compare a little bit between what the Ministry of Justice and the Minister of Justice of Brazil does and what our Attorney General and our Department of Justice does. There are similarities, there are differences, and when one talks about jurisdictional issues, it's not an easy task because both in Brazil and in the United States, the agencies sometimes change their names and they become part of another department or share the responsibility. But let me give you some idea. And let me start with our Department of Justice in the United States, which has thousands of lawyers, investigators, and agents that work within several agencies, presumably in the pursuit of justice on behalf of the citizens of the U.S. And the Department of Justice is probably best known for investigating and prosecuting federal crimes, whether you're talking about large drug conspiracies or robberies of federal banks, fraud against the federal government. And to do this, the Department of Justice has 93 U.S. attorneys, I think in 94 different offices, who are decentralized and basically are the prosecutors of federal crimes around the United States. They work together with an agency here in Washington, the Criminal Division, which is part of the Department of Justice, in the center, which is known as Main Justice, to pursue these crimes. And also within the Department of Justice, although somewhat independent in their operations, you have the FBI, the Federal Bureau of Investigation, the Drug Enforcement Administration, the Bureau of Alcohol, Tobacco, Firearms, and Explosives. And then there's some other smaller groups such as the U.S. National Center Bureau for the Interpol. The U.S. Marshals are part of the Department of Justice, and the Bureau of Federal Prisons also is under the aegis of the Department of Justice. The main difference between our Department of Justice and Brazil's Ministry of Justice and Public Security, which is the full title of Minister Jardim's ministry, pertains to the investigation and prosecution of crimes. Typically in Brazil, federal crimes are investigated by the federal police, and then they are reported to what is in effect an independent branch of the Brazilian government, the Ministério Público, which I'll call the public ministry. It's up to the public ministry, which is not the Department of the Ministry of Justice, but it's up to the public ministry to work with the various police entities in Brazil to charge and then to prosecute crimes. And again, I stress, the members of the public ministry, Ministério Público, are not members of the Ministry of Justice, whereas our U.S. attorneys are part of the U.S. Department of Justice. In effect, the public ministry, which has had a huge role in recent events in Brazil, and Minister and the Prosecutor General Rodrigo Janot is here with us on Monday, is in effect a fourth branch of government in Brazil. Now, besides its prosecutorial function, the U.S. Department of Justice has an active civil division. They represent the U.S. government both when it sues or is sued in civil matters, usually, though, in cases involving national policy, large-scale cases, and cases that cross multiple jurisdictions. And as you probably know, there's a civil rights division within the Department of Justice that is particularly zealous in seeking to enforce laws against discrimination based on race, national origin, and gender and such. Now, the public ministry in Brazil, and again, not the Ministry of Justice, does have, in addition to its role to prosecute the crime, authority in certain civil matters, particularly those that involve the larger public interest, environmental and consumer matters, they might be involved. We have in our U.S. Department of Justice an antitrust division that is responsible for promoting and maintaining competitive markets by enforcing our federal antitrust laws. There's an environmental and natural resources division within the Department of Justice that presumably is set to enforce civil and criminal environmental laws to protect the health of America and the environment. There's a tax division, among others, that ensures uniform and fair enforcement of federal tax laws in the federal and state courts, including specific enforcement activities. Brazil, with regard to antitrust, does have, as I understand it, a unit in the department, in the Ministry of Justice. There is an Administrative Council for the Defense of the Economy, CAGE, which is responsible for antitrust matters. So in that respect, there's a similarity. For the most part, as I understand it, and I can have a debate with my good friend Torquato Jardim if I'm wrong, but environmental law is more in the province of the Ministry of Environmental Affairs than in the Ministry of Justice. And that we would see with us, there is a very active and aggressive division of environmental and natural resources in the Department of Justice, although, of course, it works very closely with the Environmental Protection Agency, such as that exists nowadays. So there is some coordination with an independent agency, such as the Environmental Protection Agencies. And there are, as I've said, and also in Brazil, there are other independent agencies involving departments, really. Transportation and energy would be separate from the Ministry of Justice, if I'm not mistaken. And he says, thank God that's so. We have separate departments as well with regard to energy and transportation. The other functions of the Ministry of Justice are worth commenting on. In general, I think it's fair to say that the Ministry of Justice does help formulate public policy with respect to legal matters. To some extent, our Department of Justice does the same. The Ministry of Justice, in fact, has an internal secretariat responsible for developing consumer policy, which is, again, not so much something that one finds within the United States. I think in Brazil it's called Senecon, is the consumer agency. In the U.S., probably the agency more responsible for pursuing consumer protection agencies would be the U.S. Bureau of Consumer Protection, which is part of the Federal Trade Commission, not part of the Department of Justice, just to see. And the Federal Trade Commission is an independent agency of the Department of Justice. Another thing, interestingly, in Brazil, as part of the Ministry of Justice, technically, or I suppose historically, there is an office of a federal public defender. We don't have an office of a federal public defender in this country. They may be more or less autonomous today than they once were, but they were at least originally associated with the Ministry of Justice. We don't have a national public defender office. In fact, the public defender is recognized in the Brazilian Constitution of '88. We do have a number of federal public defender agencies, but they're decentralized. They're coordinated out of Washington, but in no sense is it a separate department. Brazil's Ministry of Justice, by decree, also has a voice in addressing certain judicial policy, at least where it intersects, I think, with the executive, but obviously there's an independent judiciary in Brazil, so to some extent the Ministry of Justice's authority with respect to judicial policy is limited. The Ministry of Justice, and you heard this, you would never hear our attorney generals talk about this, but Minister Jardim talked a lot about protecting the rights of Indians, indigenous peoples, working through a semi-independent agency, the National Foundation of the Indians, the FUNAI, Fundação, I'm not exactly all the words, but FUNAI is the Indian agency, essentially, but the major responsibility is with the Minister of Justice. The minister told the line that I'm glad he didn't use it because I had planned to use it and get a laugh, but a former Minister of Justice said that he works from tanga to toga. Well, if you know your Portuguese, tanga is a loincloth and toga is a robe. And that means that he's working with Indians one day and judges the next. And that there is that to be said. That's fair enough.
Indians every day.
Indians every day. Very well. Quickly through a couple of matters. We have a Bureau of Indian Affairs, as you know, in this country, but you may not know that the Department of Justice has an Office of Tribal Justice, so we're working at some of the same things. The Minister of Justice in Brazil, to some extent, sets drug policy, but works, as we do in the U.S., through a comparable agency to the DEA, which is the U.S. Another important role, though, you heard the minister speak a great deal about his role with the federal police, because he is essentially the chief of police of Brazil, and we don't have that exactly, although the FBI is within the jurisdiction of the Attorney General. National Penitentiary System, we talked a lot about that. That's his responsibility too. We have a Bureau of Prisons in the U.S. You don't hear the Attorney General talk much about that, but you hear the Ministry of Justice talking a lot about penitentiary issues, which of course are a very prominent issue in Brazil. The whole issue of pursuing money laundering in Brazil is much part of the activity of the Ministry of Justice. Other agencies are involved. Of course, our DOJ is likely involved. Just want to say a word finally about the Office of the Advocate General of the Union, the AGU. It is a kind of a large body of federal lawyers who consider themselves, I think, somewhat autonomous, but they are assigned to different agencies, including the different agencies in the Ministry of Justice and the Treasury and so on, the Fazenda. But they do consider themselves more or less separate in their own dealings. Well, we don't have anything like a national attorney general's office as they do in Brazil. And so that's another somewhat of a distinction. Finally, there are offices of solicitors that represent the U.S. and the Solicitor General before the Supreme Court, and there's a comparable agency in Brazil. I want to say, though, I was going to say that most of the agencies in Brazil, at least if you ask someone from the Attorney General of the Union's view, they would say, there's no longer any in-house counsel in Brazil. Well, Minister Jardim would contest that. He says everybody's got their own lawyers within the different agencies in Brazil. Then I just want a few other counterparts, because I see Paula winking at me.
Yes.
There, with regard to formulating certain policies involving the law and government, there are some agencies that are neither part of the Department of Justice or the Ministry of Justice. And for example, in Brazil, there's a National Council of Justice, Conselho Nacional de Justiça, which is part of the judiciary. And they have a lot to say about judicial policy, more so than, for example, the executive would have to say, or the legislative. We have a conference of Judicial Conference of the United States, which is a loose organization of chief judges of the various circuits and districts, and the Chief Justice of the Supreme Court. They make policy, but it's not quite the same as the National Council of Justice in Brazil. Maybe it has been said by some that the National Federal Council of Justice in Brazil is more like our Judicial Conference of the United States. Finally, Paulo, if you'll just give me another minute.
1 minute.
All right. The Minister of Justice plays a role very comparable to our Attorney General in the United States. He is a counselor, obviously counsels the President of the Republic, does have a role in the cabinet. Remember, he's the Minister of Justice and Public Security, so he's on the National Defense Council, which consults the President with respect to sovereignty and defense matters. Same with regard to our Attorney General. There is a National Security Division in our Department of Justice that develops, enforces, and supervises federal criminal laws related to counterterrorism and counter-espionage. And of course, as I say, the Ministry of Justice would take counsel with the President with regard to any matters of national importance, just as our Attorney General would. And that includes to work on the National Security Council in the United States. All right, I think I'm finished, Paul.
Thank you very much, Judge Massetti. I think Ambassador Harrington has another commitment, so he will leave us and we'll open for questions. Thank you very much, Tony.
Excuse me, and I'm sorry, Giuliano always has a tough question, so I'm sorry to miss it. I'll have to find out afterward.
Okay.
Thank you.
Thank you very much. Juliano Basile from Valor Econômico.
Thank you for the opportunity to be here taking questions for the Minister. I'd like to know, first of all, how strong... First of all, I would like to know, Mr. Torquato, how strong is your commitment with the federal police? We know that they are having budget problems. We know that They are having problems to have enough money to deliver even passports to the population. And I also like to know if you can clarify us your role as a minister. We know that the president was recorded in an inappropriate dialogue with an executive.
Your
So
qualification is yours.
yeah, sure.
Qualification is
So
yours.
I would like to hear you about that. And what is your role in this issue? Do you consider yourself a lawyer of the president, an advisor of the president, or a representative of the state? Thank you.
The federal police and every other single administrative agency in Brazil is under budgetary constraint. It's not peculiar to one individual agency. The same goes for every other ministry, every other agency. The Ministry of Foreign Relations, here represented by the diplomats, is under strong constraints. Diplomatic services are being postponed or not delivered fully because of budgetary constraints. That goes for every single ministry. The armed forces are not doing all the exercises they need. Take it ministry by ministry. The health ministry is under constraint. So every single one is under constraint. The federal police is doing its job. It's just being more objective, being creative when it comes to management. The federal police at this time is implementing 473 special operations under the orders of federal judges and federal courts. So it has to spread people and spread money thin. And the case of passports is just an option, a policy option. Less passports, but keep up health services, keep up welfare services, and passports could wait a few weeks. The money is already there, and this week they will start issuing passports again. As for my role, the Ministry of Justice is the oldest one, 195 days and 2 weeks of history. It's always been a close advisor to the president. It's always been a close advisor to other cabinet members. Its role, as Judge Messit has just described, is very wide. It covers almost everything. It is, therefore, what I try to do is to bring back to the ministry a historic role which has been abandoned recently, which is the chain of communication, the preferential chain of communication with the courts, with the federal prosecutor's offices, with the Office of the Attorney General, the Solicitor General, and with Congress. In the 5 weeks that I've been in office, I have personally met with about 100 members of Congress, which is 1/6 of members of Congress. The Committee of Public Security of the Chamber of Deputies had a special meeting at my office to discuss issues of public security. So this is the role the Ministry of Justice. I stand for the ministry stands for the Republic. It is an advisor to the President, and just like any other in the past 195 years, he will be as close an advisor to the President as close as he is personally to the President.
Thank you very much.
Maybe you want to correct me because I mentioned the inappropriate dialogue. So do you think that the dialogue was inappropriate between the president and Joesley Batista?
That issue is in court, so I'm not the counsel for the president in court. So I'll let Dr. Maris answer to that.
Okay, BBC.
Good morning. I work for the BBC, Brazil. Your visit to Washington, D.C. was described by the Brazilian media as a response or as a counterbalancing to Mr. Rodrigo Janot's visit. I would like to hear from you if that makes sense. And we haven't heard you talk a lot about the car wash operation. Mr. Janot, yes, he talked a lot about it. I would like to know, nothing is perfect, probably Lava Car Wash is not perfect as well. What are your critics to this operation? Thank you.
Not the Brasília media, one newspaper. No, Jean-Louis and I have known each other for many, many years. We have worked together in the past. We have great friends in common. We have always spoke to each other whenever it was necessary. Even when I was at Transparency, I went to him a number of times to work out a modus operandi with the Ministério Público for the leniency contracts, leniency negotiations. We have no difficult talking to each other. We have exchanged messages here in Washington, etc. The two trips were planned entirely separated. I only heard of his own trip through the papers, and I called him and told him I'd be in Washington the same days and who would be here, same place as well. It's a total coincidence. It's not planned in other way. As for Lava Jato, it's been a year that I have been saying this. It is a gang of our society. It's unstoppable. Whatever needs to be done will have to be done under the Constitution, under the laws, either by the Ministério Público or the Federal Police or Ministry of Justice. Whoever is involved, whichever institution is involved, is deeply committed to taking the job to an end, and the job will be taken to an end.
Thank you. Isabel from Folha de São Paulo.
Good morning, Minister. I'd like to ask you about an article that was published yesterday by Valor Econômico. It's about a possible accord between the investigative authorities between Brazil and the United States to record, to wiretape President Temer here in a supposed trip that he was supposed to make in May. What do you have to comment on that? And
I have nothing to comment because I know nothing about it.
But is the Brazilian government going to ask?
I have no idea. I have no idea what the reaction will be. I have not talked to anyone about it.
Okay, thank you.
Yes, please. Right here.
Good morning. Thank you very much indeed for your presentation. My name is Hector Luisi. I'm a retired international civil servant. My question is more to the philosophical rather than with the day-to-day. I was very taken by your comments, by the judge's comments. My experience and that of my family, which have been in Brazil now for 109 years, is that the judicial system, as opposed to my own country, Uruguay, the United States, which I know, and France, which is a country of my wife, is that judiciary outside of the urban centers, Sao Paulo, Rio de Janeiro, is extremely distant from the regular Brazilian citizen. What you have spoken very eloquently is to the people I know and which my family have known for 109 years, almost Martian. And that distance, my question therefore is, how do you reconcile in a modern democracy this enormous distance between the judiciary, which is key to any democracy, from the ordinary life of the ordinary citizen, particularly as you distance yourself geographically? I'm from Mato Grosso do Sul. Thank you very much.
Sotero, I need a kind of 60 hours to answer that question.
Okay. We can schedule
It's a
another
full
event,
course.
but-
It's a full course. It's a full course. And a full course of comparative sociology, comparative law, comparative psychology, comparative demographics, because that challenge is posed to any single country in the world. And things are more difficult in Brazil, perhaps because of geography, perhaps because of the discrepancies in per capita income. So As I said, 60 hours.
Let me
what
just
we
try-
do is to decentralize the organization of the judiciary in state careers so that judges, state judges in each area of the country, each state of the country, can try to better respond to local needs. But again, I go back to my proposition of the preeminence of a national government, national laws. We have this naive perception that one general law out of a Brazilian Congress in Brasília will solve the problem for everyone in the country, which is not true. But again, it will be a specialized course, not an LLM course, a doctoral course.
Miss, just for a 30-second answer, is it, yes, it's distant. Is it as distant as it used to be, or after what? 30+ years of democracy, there is more of a proximity now.
Well, the judiciary has become more active. The newest generation of judges, let's say, below the age of 40, almost half of my age, those judges have brought in a new perception of social commitment. Brazilian law has become less formal, more socially engaged. So more often than in the past, you will find courts and district court judges responding more effectively to social needs than it would be in the past. Less concern of standing, other procedural issues, and more commitment to substantive law.
Let me offer a quick comment as well. You're really, I think, talking about access to justice of people at a lower scale to a certain extent. And there is an issue of access to justice of people who are not in the upper reaches of society. Brazil has tried to come to terms with that to a certain extent. They have the small claims court, the Juizados Especiais, that are trying to deal with more everyday problems, although in some ways the Juizados have become victims of their own success. But they're interesting stories. In order, for example, to try and bring Social Security benefits to some of the Indians in the Amazon, they're actually floating boats that have gone up the river called Justiça Itinerante, in which they've tried to offer legal services to people who are not accessible to justice. So there are issues where things are being tried. I might say this, access to justice is a challenge of every country, including the United States and other countries along the way. But it's sort of like the old joke that when they asked the comedian Henny Youngman, how's your wife? He would say, compared to what? You know, I mean, the issue with Brazil is compared to what? Compared to who else? And in my experience, which is fairly broad around the world, Brazil is making a reasonable effort to kind of expand access to justice.
Okay, I will ask one question. There is a famous lawyer, jurist in Brazil, Modesto Carvalhosa, that has been, I see him every week now in the papers, advancing the idea that in order to overcome some of the difficulties you describe, institutional difficulties, obstacles that are built in our Constitution, the way we put together this package, that we should rewrite the whole thing, that we should have an exclusive Constituent Assembly, etc. What is your approach? What's your perspective? I'd like to have your comments on that.
I've known Modesto Carvalhosa for 40 years. We had lunch recently. He's a bit too radical. Nothing starts from zero anymore. Not in politics, not in sociology, not in law. There is history behind us. So we can build something, transform evolution, not revolution. Enough for revolutions, evolution. Let's build up on what we have. And we have a very rich history of law, and particularly in the past 30 years. So let's build on it. Let's improve on it, not start from over.
Okay, and going back to my old habit of a journalist, where should we start? This is your view. In order to have a productive conversation on that, because it is recognized that it's too cumbersome. We have, it's not workable, and you just gave us a description this morning how difficult this is. Where to start?
Congress. In a democracy, anything, everything must begin and end in Congress.
Okay, and you are invited to be in a panel of advisors to Congress to propose a few things that you think would open the way to a productive discussion. Where to start?
in Congress with congressmen. I would not draw initiatives out of the blue. I would sit with them and ask, what do your constituents want? What do your constituents put you here for? They are the channel of communication. Enough of academics. Enough
Okay.
of genius, academic genius sitting in chairs in the government. I'm not one of them, but enough of that.
Thank you very much. Ladies and gentlemen, questions for the minister? Yes, there is one there. Professor Joe Page, Georgetown University, of all places.
Is this
All
working?
places, my old school.
Is this working?
Yes.
Okay. Yeah, I'd like to get back to something that Minister Jardim mentioned or hinted at a little bit ago, and that has to do with what some people have called the judicialization of politics in Brazil. It's a question of institutional competence. That is, the judges in Brazil, at least from the perspective of someone trained in the United States and familiar with American law, the judges in Brazil seem to be doing things that they may not be competent to do. They seem to be answering questions, resolving problems that involve not the rule of law, which is what we're supposed to be guided by, but questions of public policy, questions involving discretion, how many years or how should we deal with these problems of inhumane conditions in the prisons, how much money should be spent on different public health issues that now seem to be decided by the courts. So are we talking here about rule of law, or are we talking about rule of judges? Is that what's happening in Brazil? And is there a danger here that the judicial system, that the judges are doing something that they really are not suited to do? And is that really democratic? That is, is this a democracy when unelected judges are the people who are making these decisions? And also, if that's really what is happening, why is it happening? Is it because of a failure of other institutions, and the judges are moving into a vacuum, or they're being pressed, or by their own sense of right and wrong, or concern for their country, they feel it's necessary for them to make these decisions because the other branches of government are not making them?
Yes.
Why don't we write a book on this together? You're the professor. I was a student at Georgetown. I would say that I'll just say the obvious. Oliver Holmes once said that sometimes one needs to state the obvious. As in physics, as in nature, in politics also, there's no vacuum. If the judges fill in, it's because either the executive and or the legislatures are not doing their jobs. So they're filling in. And there's this new perception of constitutional law in Brazil called neo-constitutionalism, which is if the Constitution states right A must be implemented. If there's no executive order or legislative act, the judge will issue the decision, case by case, or a case-by-case basis. It's vacuum. All this Lava Jato investigation has put politicians in check to the extent they are inhibited. They have their own agenda, let's put it this way. So judges fill in, jump in. There's newest generation of, and the leader of this intellectual movement, one of the top leaders of this intellectual movement, will be your guest here in September, which is just Luis Roberto Barroso, an old friend of mine. So the leader of the new wave, progressive rock, progressive constitutional law, is in the court. So it's up to him.
Okay. Professor Page, you're going to be here on September 8th with us, okay? To ask that question. I have a question about something you mentioned referring to TCU, the General Accounting Office, or the Tribunal de Contas da União. And I had been surprised by this role of the TCU that says that, well, they have a set of public policies and priorities, and the ministers have to come and explain to them to see if what they are implementing is compatible with what they have. Who developed that? Who elected the Tribunal de Contas da União to develop public policy? What is that coming from? Since they are part of Congress, is that something that the members of Congress outsourced to them, or is it not? Because it's difficult to understand.
It's a good question. TCU has double role. Article 71, Roman 1, it is an advisory body to Congress to approve or not approve the budget as implemented by the president. Under Article 71, Roman 2, TCU becomes a an administrative court with judicial powers. And they have developed that power unto themselves out of this constitutional clause. Who chooses them? There are 9. 3 are appointed by the Chamber of Deputies, 3 are appointed by the Senate, and 3 are appointed by the President. So there are 9.
But aren't they sort of, to use a strong word, usurping from Congress the responsibility that is Congress?
No, not in that role, no. Under Roman 2, 71, inciso 2, 71, inciso 2 of the Constitution, it is their role, not the congressional role.
Okay.
It's quite well divided between the TCU and the National Congress.
Okay, so they judge under what? Some public policies, some objectives that are stated in law or in government plans.
Yeah.
That's the criteria for judging, okay? One more question, if we have. Yes, please, identify yourselves, and this will be the final question. Thank you.
Hi, it's Daniel Trielli from the AP. As an advisor to the president, how do you and the ministry and the government itself feel about the possibility of new charges coming from Janot to Temer, derived from that recording? Is the government hesitant? What's the feeling of the government about that?
We'll do what we have to do. Let's see what happens first. The ball is on their court, not on our court.
Well, with that, I would like to thank you very much, Minister Torquato Jardim, for having been with us here, accepting our invitation to come to the Wilson Center. Judge Peter Massetti, our partner in the series, and obviously Ambassador Harrington, with all of you that have been following this proceeding, as you have done in other cases. We will produce a text based on your statements here and Q&A. We are going to, by the end of the year, put those lectures together in the form of a book and make available probably online because we are mindful of keeping our footprint very small. But it's been a pleasure. We do this in the spirit of democracy. Thank you.
Thank you.